14 months of tenure, a single corporate president, a severance payout valued at roughly $130 million. The trial court evaluating this payout called the board's decision-making process a model of how not to govern. Yet ultimately, every director was cleared of legal liability. The litigation centers on the precise boundary between a board's bad governance and its unlawful governance. This diagram illustrates the gap at the center of the case. The lower baseline represents the legal floor of fiduciary duty. The upper boundary represents the aspirational ceiling of best practices. The Disney board's conduct occupied the vast space between them. Chancellor Chandler emphasized that Delaware law does not hold fiduciaries liable for failing to reach an aspirational ideal. He cautioned that measuring stewards against ideal practices would discourage the risk-taking essential to corporate growth. In 1994, a fatal helicopter crash killed Disney president Frank Wells. Shortly afterward, Michael Eisner underwent quadruple bypass surgery. This double crisis left the company without a clear successor. To fill this corporate void, Michael Eisner turned to a trusted 25-year friend. Michael Ovitz was the founder of the Creative Artists Agency. He owned 55% of his firm and earned roughly $20 million a year. To recruit him, Disney offered significant downside protection through a non-fault termination clause. The board process for this hire was remarkably brief. The compensation committee met for 1 hour, reviewed a term sheet rather than the full contract, and granted unanimous approval. The board committed the corporation to a massive potential financial penalty with minimal internal debate. The relationship unraveled under a culture clash. Sanford Litvak, Disney's general counsel, repeatedly advised Eisner that there was no legal cause to fire Ovitz, describing the lack of cause as a no-brainer. Michael Eisner terminated Ovitz unilaterally, without seeking a formal board vote. This abrupt action immediately triggered the massive non-fault termination payout. Shareholders responded with a lawsuit, leading to a 37-day trial in the Delaware Court of Chancery. Delaware's statute shields directors from negligence. A duty of care claim yields no monetary judgment. To bypass this shield, plaintiffs had to prove bad faith. Only bad faith rebuts the business judgment rule, shifting the burden to entire fairness. The case turned on whether gross negligence, specifically sloppy and uninformed decision-making, could be legally categorized as bad faith. In his trial opinion, Chancellor Chandler ruled that while the board's conduct was far from ideal, it breached no fiduciary duty. He characterized Eisner's management style as imperial and Machiavellian. However, he found Eisner acted in subjective good faith because he remained the most informed participant throughout the process. The court defined bad faith as an intentional dereliction of duty or a conscious disregard for one's responsibilities. Because Eisner was factually informed, his unilateral process did not meet the thresholds for gross negligence, shielding him from liability. In 2006, the Delaware Supreme Court affirmed the ruling. Justice Jacobs's unanimous opinion formalized a strict taxonomy of fiduciary conduct. Category 1 is subjective bad faith. This involves conduct motivated by an actual intent to harm the corporation. Category 2 is gross negligence. This involves a lack of malevolent intent and is protected by Delaware's exculpation and indemnification statutes. Category 3 is the intermediate space of intentional dereliction. The court held that gross negligence, without more, is not bad faith. This distinction is a matter of statutory logic. Conflating the two would undermine the legislative protections of the exculpation and indemnification statutes. The court also cleared Michael Ovitz. It ruled that the corporation imposed the termination on him, and a fired officer owes no duties regarding the terms of his own removal. The claim of corporate waste was also rejected. A contractually obligated payout arising from a rationally purposed employment agreement cannot constitute legal waste. The outcome was unanimous across both levels of the Delaware judiciary, with no judge filing a separate or dissenting opinion. The plaintiffs argued that the business judgment rule effectively licenses passive boards, and that making a materially uninformed decision should itself be considered bad faith. Justice Jacobs rejected this, characterizing the attempt to conflate care and good faith as pulling a rabbit into the proverbial hat. This holding clarified that bad faith remains distinct from gross negligence, maintaining the high threshold for personal liability. While the court was unanimous, the legal academy was not. The ruling sparked a wave of critical literature regarding executive compensation and the limits of good faith. Months later, in Stone v. Ritter, The Delaware Supreme Court held that good faith is not a freestanding third fiduciary duty. This recharacterized the Disney holding, folding the conscious disregard category into the broader duty of loyalty. Today, we must ask if the gap between the legal floor and the governance ceiling has narrowed in the era of Sarbanes-Oxley and Dodd-Frank. It remains to be seen if mandatory say-on-pay regulations provide the discipline that the business judgment rule avoids imposing. The critique of the imperial CEO takes on new relevance in today's era of founder-controlled, dual-class technology firms. Dodge versus Ford asked what the corporation is for. Disney answers how its stewards must act, demonstrating that fiduciary duties evolve by testing their limits.